A good place to start would be the categorization of these licenses into 5 broad categories. These are licenses in respect of works unreasonably withheld from the public, licenses in respect of orphan works, licenses in respect of works for the differently abled, translation licenses, and licenses in respect of reproduction and sale of works unavailable in India. Section 31 of the Act, which deals with licenses in respect of works that are withheld from the public, is indeed one of the most controversial provisions when it comes to the aspect of compulsory licensing, and therefore we'll dive straight into that. This provision has a few preconditions. The first is that it is applicable to any work and it must already have been published or performed in public, that is the work in question. The second is that there must be a complaint alleging that the copyright owner has refused to allow the republication of the work or to allow broadcasting of the work on terms that the complainant considers reasonable. The third is a reasonable opportunity of hearing to the copyright owner. And the fourth is a satisfaction on the part of the adjudicating copyright board that the grounds for refusal by the copyright owner are not reasonable. So the structure of this provision entails the filing of a formal complaint by an applicant for a compulsory license and the showing of some of these preconditions by the applicant. Once the applicant satisfies the copyright board that there has been an unreasonable refusal to broadcast the work, and as a result of which the work is being withheld from the public, in that event the copyright board can then direct the registrar of copyrights to issue a compulsory license in respect of the work in question. There are many controversies that surround this provision. One of the major controversies is regarding the grant of bulk licenses for several works. Can there be one application or has there to be many more applications, as in multiple applications in respect of different works? Currently the philosophy, or at least the way the law is being implemented, it looks as though one application is enough, and this is based on the experience of working with one particular set of disputes in the broadcasting industry, wherein radio broadcasters had filed compulsory license applications against the owners of sound recordings, multiple sound recordings, but in the form of one particular complaint to cover all these recordings. There the copyright board and even subsequently the Bombay High Court and the Supreme Court seem to take the view that one application would suffice to cover the different works. The next important question is, what do you lay down as the correct test to assess whether just compensation has been paid? Because the provision again speaks of payment of compensation. So what is compensation? In the first set of disputes before the Copyright Board in 2002, the applications filed by the radio broadcasters as mentioned now, the board took the view that in the interim period, that is before the disposal of the main application for the compulsory license, the court could still fix rates of royalty based on a best judgment assessment. Now this was challenged and it went up to the Supreme Court, and the Supreme Court, in a manner akin to equating copyright with the broad proprietarian philosophy of being covered as part of the rights of private property held by an individual constitutionally, held that there cannot be confiscation of such property without payment of compensation, and compensation by its very definition had to mean something which was equivalent to the worth of that particular property. So here we clearly see a sort of merging of the proprietarian doctrine with the socialist philosophy of a compulsory license, when the court is trying to read in the proprietarian dimension to the social license, rightly or wrongly. This is also seen in the court's approach to the grant of interim compulsory licenses, where the Supreme Court has quite recently taken the conclusive position that one cannot grant such licenses, that the Copyright Board cannot grant such interim licenses, and that licenses can only be granted after a final disposal of the applications. The reason the court again took this view, at least as evident from the concurring opinion by Justice Chalmeshwar, if not from the majority, is that there is a very serious right involved here, and the right is being derogated from, and when there is a derogation of the right, it can only be based on evidence led at the time of trial. And what is this right? Justice Chalmeshwar indicates that this is nothing but the property right. So again, the proprietarian dimension of copyright is brought in here and kind of superimposed on a social licensing scheme in a manner which attempts to merge the two different philosophies. Now, in practice, this provision has not really worked in the best manner as one would desire, as amply borne out by the set of disputes relating to the radio industry. Compulsory licenses applied for in 2002 got mired in litigation and were finally disposed by the board in 2010 and have led to further litigation. So the way the provision currently seems to work, it is mired in considerable ambiguity and absolute lack of clarity on the way in which royalties must be determined by the Copyright Board. The board in its 2010 order has fixed the rate of royalty based on a percentage of the net advertisement revenue earned by the radio stations. The counter standard, which is sought to be put in place by the content owners, and which they argue is an equivalent or a just equivalent of what the work is worth, is based on needle hour rates and they argue that radio stations must pay based on rates fixed per needle hour. That is the time when music is actually played in any particular hour over the radio station in question. The law currently provides no guidance in respect of any of these matters, and hence the provision remains an unworkable formula in respect of providing access to works withheld from the public. Quickly moving on to orphan works and the compulsory licensing provision. Orphan works are a term of art denoting situations where the author of the work is dead, unknown or untraceable, or the copyright owner cannot be found. The application here is under section 31A by any person who is desirous of publishing or communicating to the public such work or a translation of such work. The main conditions for pre-application and the consequential grant are publication of the applicant's proposal in a English daily newspaper, deposit of royalty by the applicant to any account specified by the board. Empirically, this provision has not been used much, but it may have a lot of relevance post the growth of the Google Books project, because many of the works which Google Books project seeks to reproduce are orphan works. So what happens with these orphan works? Can Google Books, for instance, go ahead and do what they would like? No. Section 31A exists, and as long as it is in the statute books, they will have to comply with the provision in order to reproduce it as part of their database. But it does certainly provide them with a way out. Though the provision may not be entirely conducive in terms of publication in the newspaper and so on, at least as a matter of its philosophical justification, it seems a laudable provision to have.